Now let's chat to Mbekezeli Benjamin from Judges Matter on this particular story. Mbekezeli, good morning and thank you very much for your time. Now, before we get to Friday's judgment and perhaps your views, one would think it's important to trace our steps back to that 2019 judgment, which found that it was inexplicable for the inquiry to have ignored essential information before concluding that there was no corruption or improper influence. How important was that particular judgment, just setting aside those commission findings in just the broader accountability project by civil society?
Good morning, Fundo, and to everyone watching us this morning. Well, that finding was actually quite a crucial one because it was the court looking quite closely at how the arms deal inquiry followed its process and how it assessed its evidence. And there were serious questions about how that inquiry went about doing its work. Eventually, the High Court said that it was irrational for the inquiry not to consider certain evidence, to ignore certain witnesses, and come to the conclusion that no one could have been found liable for the arms deal corruption that we saw. So it was important because it set in motion a sequence of events that culminated in the judgment that we saw last week.
Now, among the criticisms of the Commission's work back then was its refusal to admit the record of proceedings from Shabir Sheikh's criminal case. I mean, many failed to understand why the judges wouldn't view Shabir's case as some sort of a helpful tool when Shabir had already been convicted for soliciting bribes from the arms deal. And it was now a matter that was before them. They were seized with the very same matter. Was that honestly a wise decision?
Well, it turns out that it wasn't such a wise decision because one would have imagined that if you reject the proceedings of a criminal trial where I think the highest standards of evidence are used, then you must have a really good reason for doing so. And from the court judgment, it doesn't seem that there was any real reason why that evidence was ignored. And that's probably why the High Court eventually said this whole investigation was irrational. It came to irrational findings based on not considering important evidence like the proceedings at the criminal trial.
Then to Friday's judgment, the pair their challenge was dismissed, but they had essentially come before the court to challenge the definition of a judge, saying, as a start, they shouldn't be regarded as judges for the purpose of disciplinary proceedings because they are in fact retired judges. What did you make of just that argument alone?
Well, I was stunned by that argument because to me it seemed as if there was a sort of avoidance of accountability because for all intents and purposes, retired judges still earn a salary from the state. They earn the salary until they die. So it can't be that you then say, I'm not a judge, even though you're happy to accept the salary of a judge. So for me, I just found it mind-boggling, and it was quite surprising to hear from such senior members of our judiciary.
And because that salary is not reduced at all. It's not as though maybe you earn a specific salary whilst a judge and then once you're out of active service, then the salary is somehow reduced. But when reading Judge Sutherland's judgment, he actually makes the distinction between two phrases: discharge from active service and the phrase termination from office. And he says that discharge from active service is the term that is used for retired judges, which he states is very important because it points to the continuing judicial identity, even though a judge is no longer performing a judicial function.
Yes, that was a crucial distinction that Justice Sutherland made, because what he was saying is that you can't tie the identity of a judge with the holder of an office. It's not like it's a temporary thing that ends at a certain point when your formal office ends. It is a lifetime commitment, and it is tied to the principle of judicial independence, which is almost sacrosanct in our constitution. We want our judiciary to always be independent, to be impartial, and so that's why we protect the security of tenure of judges, that if you become appointed as a judge, you will die a judge, unless, of course, you decide to resign. But outside of your resignation, you still continue to be that judge. And that was a crucial point that Judge Sutherland made in the judgment. And I think also on the question of accountability, because here, the two civil society organizations, Open Secrets and Shadow World Investigations, what they are trying to do is essentially hold the judges accountable. And before the JSC could even start with the accountability, the two judges challenged the legislation, which sometimes someone can read it as an avoidance of accountability. And that's also something that we don't want our judiciary to sort of perpetuate, that judges are beyond accountability. That shouldn't be the case.
And I noted as well that Judge Sutherland in that judgment stated that in no means is his judgment speaking on the merits of the allegations. No, he merely just dealt with that which they have challenged, which is the JSC Act. And he dismissed that part because there can be sometimes the confusion that now they've been found guilty of some sort of conduct when they haven't as yet.
Yeah, so that's an important point, Mfundo, because at this stage, there's still going to be a formal investigation into the judge's conduct. So I don't want to preempt and say the judges have done anything wrong. At this stage, the JSC will still investigate and they will test the allegations. And they might very well find that the judges did absolutely nothing wrong, because it is this is a novel situation. We've never before had judges been held accountable for duties that they performed at a commission of inquiry. So at this stage, what should have happened is that the JSC should have went ahead with its responsibilities, and then the judges await the outcome. If they're not happy with it, then they may challenge it. But to challenge the legislation at this early stage, I think that was what was problematic. And so the judgment on Friday was really, really important for judicial accountability.
Mbekezeli, thank you very much for your time this morning. That was Mbekezeli Benjamin from Judges Matters.